Welcome back to the channel, friends. This is your Govindaraj. Thank you very much for watching all the previous videos and also sharing it in your network. More importantly, being in the membership channel. I'm going to talk an important subject today. When the WC insurance is obtained by the principal employer, whether it covers the liability of contract employees also. So normally what happens is principal employers will have their own WC insurance to cover these eventualities or any subcontract workers or contract workers. So in such a case, if the principal employer has taken this policy of WC, in case contract employees or the subcontract employees gets into injury, then in such a case, whether that policy obtained by principal employer, whether it covers or not, is the topic of our subject today. If you look at section 12 of the act, as I have already told you in the previous videos, the responsibility is very clear. The obtaining insurance actually is not a mandate, because the statute does not mandate any insurance either in the hands of the contractor or the principal employer. So therefore, it is a voluntary measure by the employer to cover the liability in case of any liability due to accidental insurance. So this, when insurance is obtained, it is possible that insurer may have an exclusion clause with regard to contract employees if the same is not disclosed by the employer or specific insurance not obtained. Because if you look at, they may also bring up and argue that there is a privity of contract with the contractors or the subcontractor is not available. It does not exist, because the insurance is like a contract between the employer and the principal employer and the insurance. Whereas even the employees of subcontractors and contractors are not the employees of the principal employer, then there is no privity of contract with those subcontractors. So therefore, in such a case, this insurance company may also bring up issue that the contract employees and subcontract employees are not covered in under the principal employer's insurance. So that is possible. But however, if the principal employer is intelligent enough to cover all these people, he may disclose in the beginning and ask the insurance company to cover very specifically and also include all these people. But if that is not done by the principal employer, then what is the remedy is our important topic. So as I've told you, the question before us is, even when the contract employees or the contract works are not disclosed, whether the WC insurance or workman compensation insurance obtained by the principal employer covers the contract employees also. That is the very important topic which we need to understand. I have highlighted this very particular section or provision under section 12 of the Employees Compensation Act. It very clearly, these wordings are very clearly explains that the principal employer is liable for employees employed for his works, except the wages which needs to be obtained from the contractor for calculation of the compensation. See, principally the subsection 1 is telling that even in case of contract or outsourcing works, principal employer is responsible as an employer, but when it comes to calculation of compensation and wages, he can take the wages from the contractor. So in such a case, so this is very clear that the liability is very clearly cast on the principal employer. So therefore, even when the insurance has an exclusion clause, such an exclusion is in violations of the provisions of this section, because the very object of taking the insurance is to cover the eventualities and liabilities in such a case. So the insurance company should not take up a plea that the contractors and subcontractors are not disclosed and we don't cover. So they cannot take such a plea, because if there is any such clause, such condition in the policy, it does not sustain in the eye of law. So it doesn't serve the purpose of the law. So therefore, the courts have held that, especially I am giving you the apex court in the case of Texco Marketing Private Limited versus Tata AIG General Insurance Company Limited in 2023, gave a principle that an exclusion clause has to be understood on the touchstone of the doctrine of reading down in the light of the underlying object and intendment of the contract. It can never be understood to mean to be in conflict with the main purpose for which the contract is entered. So the meaning is that when the contract with the insurance company and the employer is entered into, the purpose is to cover the liability under the statute. So when the statute itself casting the liability on the insurance, liability on the principal employer, then when the insurance company comes up and puts a lot of exclusion clauses, that doesn't serve the purpose. So therefore, even if there is a condition in such a policy, then that is against the provisions of section 12. So therefore that don't sustain in the law, and they are violative of law. So if you look at recently also in the case of the Honorable Madras High Court, in the case of New India Assurance Company Limited versus Sivanath Perumal and others, we very clearly held that the principal employer's insurance to cover contract employees even when there is no privity of contract. So even there are exclusion clauses. So therefore, the moment the principal employer has taken the policy under WC, it covers his employees as well as the contract employees also. Now next question also, let me give you some answer. How about subcontract employees when the main contractor has obtained the insurance? So this is very also tricky. In most of the cases, when the principal engages a contractor, so he will not execute all the works. So he will engage certain subcontractors for certain activities. So in such a case, if the main contractor has obtained the insurance, whether that insurance also covers the subcontract employees? Answer to this is, in such a case, the main contractor will be deemed as principal employer. So therefore, even when there is a exclusion, it cannot be allowed to operate. Hence, the employees of subcontractor are also covered under the insurance obtained by the main contractor. So this is also very clearly held in the case of New India Assurance Company Limited versus Sivanatha Perumal and others. The Honorable Madras High Court has very clearly held that. So therefore, when the main contractor has taken the insurance, that itself covers his subcontract workers also. So therefore, the law is very clear on this topic, friends. Thank you very much for watching this video, and also stay tuned in the membership channel, because I'm going to come up with more and more innovative topics like this, so that you can enlighten yourself and solve all your compliance issues. You can save more time and your legal costs. So if you start watching all these videos, and thank you very much, friends, and see you soon in the next video.